Welcome to the Liberty Perspective. I'm Joe Marshall. Today I'm going to try and wrap up this series that I've done on First Amendment auditors, or constitutional auditors, as it were. I'm trying to bring you some information, some things to think through, opportunities to kind of experience what some of these officers have been being put through. Not just officers, not just law enforcement either. They're going into a lot of public buildings, or pretty much any public building, public employee, what they say is public property, public offices, even if they're run by private entities. They'll go in there, libraries, post office. It doesn't matter. The civilians that they come across, it doesn't matter. So I want to kind of go across some of these things, kind of pick up where we left off. And I remember what we were talking about at the end there. We're talking about Paul Reyes' record, and I kind of went over, found some evidence that he had been a convicted felon, that he's a convicted ex-felon, or he did time for felony charges, attempted first-degree robbery in New York State, that he was incarcerated, and while incarcerated, he dropped lawsuits, which is kind of his MO anyway, right? He sued the state after having an altercation with other inmates. Kind of, they beat him up pretty good, and then he sued the state. But I put in here that I started it out, are these police departments, because he was complaining, or was bragging about how he's now training police departments and attorney general's offices, and he's doing ride-alongs, as you can see. As you can see here, you know, he was doing ride-alongs with officers, you know, just inches away from the officer's arsenal in the car. He says he's training these police departments, including the one that this officer was with. But do they know that this guy appears to be the evidence? We have reasonable cause to believe, with the evidence that we have found in public records, that this guy is a violent ex-con. Charged and did time for it, was convicted of a violent felony, Class B felony of robbery in the first degree, attempted robbery in the first degree, right? So I was like questioning, are these police departments, not to mention DA offices, Reyes himself is speaking of, aware that this guy, they're having training, their offices and officers, and doing ride-alongs with them appears to be a Class B felon or offender, ex-con, however you want to say it, offender, whatever. Now, in the last video, I said, that's not a Class B, it's Class A. I had some mistake. It's Class B. I had it right the first time. But anyways, I want to go down through this. We kind of went down through this. You see the last video, we went down through his charges, right? Robbery first degree. He was at Mohawk Correctional Facility. Prior to that, according to his own lawsuit, I took a screenshot here of it in case the website that I found that information on disappeared, as things tend to do. Learn a little bit about what that charge was, what that felony robbery in the first degree attempt was, and the criteria that you have to have in order for it to be attempted robbery in the first degree, which is one of the most robbery in the first degree is considered a violent crime. Not only that, it's the most serious crime, robbery, most serious robbery charge, and that either you had to get somebody hurt, or you had a weapon, or you threatened to use a dangerous instrument, which really could have been anything as a weapon, right? But we learned a little bit about that. If you wanted more information, you check out that last show. We went down through his lawsuit that he put against the state, because after he got put into, it's his MO, he puts in lawsuits. He puts in a lawsuit against the state. That information is public, right? I don't know. But anyways, we found it online. Found that information online. I read down through that, found out what that incident was about, and I wanted to start to get into the Right to Monitor Act a little bit. he's a lot of times on these shows, he keeps talking about, keeps bringing up a right to monitor act, that we have a right to be here. I have a right to monitor corrections officers. He's got a typical particular grudge against corrections officers, but all law enforcement altogether. But he keeps bringing up this right to monitor act, so I kind of wanted to go down through this a little bit with you. And it was a little bit of information with the title. I got this information that I got here. Let me see if we can get it to go. Doesn't want to go. Oh, there it is. Okay. Got that information on what the bill was then. The title of the bill is an act to amend the civil rights law in relation to recording certain law enforcement activities. The purpose of this legislation is unambiguously affirm by statutory enactment the right of New Yorkers to record, with expressed exceptions, the actions of persons acting under the color of law. Summary of specific provisions. Section 1 of the bill provides that the act shall be known as New York Right to Monitor Act. Section 2 of the bill adds to the civilian right law entitled Recording Certain Activities. This section includes definitions, delineates the right to record law enforcement related activities. It creates a right. The law creates a right. That's just I don't know how that's human rights law. That's positive law, creating our rights from our founding principles. The government we don't get our rights from the government. Laws don't create rights. Our rights are natural rights that are actually protected and secured in our Constitution, as you were. Secured is the word. But that's a philosophical question, but I just kind of wanted to point that out. It's kind of weird that they would say that. It creates a right of action for persons who suffered an unlawful abridgment of their right to record in an affirmative defense of persons charged with a violation of this right and preservation of rights. Sorry. Section 3 of the bill includes a severability clause. Section 4 of the bill provides the effective date, justification. So justification for the Right to Monitor Act. The First Amendment of the United States Constitution openly confers and protects the right of ordinary civilians, to record police activity. The right of the people to document public activities of law enforcement helps to ensure that police and other engaged in law enforcement activities are accountable to the public. Right. Let me see. An act to amend the civil rights law. We'll see. In relation to recording certain law enforcement activities. This act shall be known and be cited as the New York Right to Monitor Act. Recording certain activities. Officers means any peace officer, police officer, security officer, security guard, or similar official who is engaged in law enforcement activity. I mean, everything that an officer is doing or any government employee is doing at any given time isn't always being engaged in law enforcement activity or government activity. I mean, sometimes you're getting a drink of water. I mean, sometimes you're going to the bathroom. Sometimes you're in an area where, lunch break. I mean, and you have those employees still have a right to their, safe and secure environment, and their constitutional rights don't end just because they're clocked in, But these guys, these auditors, are coming into buildings, they're putting the cameras in the faces to all these employees. And even if they are doing state business or government business or doing law enforcement activity within a, precinct or in buildings within a prison or on prison grounds that are secure areas doesn't necessarily broadly just mean that he can go in there and do it just because there's a sidewalk or a door or there's public access or apparent public access or claimed public access to it. Just kind of thing I just want to put out there to, just put it out there for your consideration. And law enforcement activity means any activity by an officer acting under color of law. So, I mean, you're not acting under color of law when you're on lunch, when you're just walking the halls, or it's not necessary. I mean, when you're enacting an arrest, you're given lawful direction. You're acting under color of law, right? Right to record law enforcement related activities. However, that person in custody. Let me see what we're saying. Record means to capture or attempt to capture any moving or still imaging sound or impression through the use of any recording device, camera, or any other device capable of capturing audio, moving or still images, or by way of writing notes or observations. To the right to record law enforcement related activities. A person not under arrest or in the custody of law enforcement official has the right to record law enforcement activity not under arrest, right? Has the right to record law enforcement activity and to maintain custody and control of the recording and of any property or instrument used by that person to record law enforcement activities provided. However, that person in custody or under arrest does not, by that statute alone, forfeit the right to have any such recordings, property, and or equipment. So, boy, I tell you what, you want to walk balancing beams? Who's going to dodge the open on that? I guess whoever pays whatever lawyer gets paid the most money wins on the interpretation of that, right? Maintain and return to him or her nothing in this subdivision shall be construed to permit a person to engage in actions that physically interfere with law enforcement activity or otherwise constitute a crime defended in the penal law involving obstructing governmental administration. There it is. Obstructing governmental administration. Obstruction, right? But anyways, I just wanted to give you that, Right to Record Act and a little bit of information on that. And it's not absolute. It doesn't mean everything, everywhere, all the time for everybody or anybody, right? There's limitations. Time, place, and manner is one of them, as you'll see in a lot of legal observations on this law, on anything on what they're doing. Freedom of speech. You good? Good. All right. Who's that? Me, Pete. But anyways, you got time, place, and manner. That's one of the big considerations legally that it's not absolute. It's not everywhere all the time for anybody. Got a couple lawyers here. Local Government Bulletin, responding to First Amendment audits in the local government context. Got some information on what these First Amendment audits are from a legal perspective. I got this information from here. Local Government Bulletin 141, and then these lawyers were on there. But just to give you who the authors were, a little information on who they were. Professor of Public Law and Government. This was one lady, the Albert. She's assistant professor. So you got a professor and an assistant professor of law. Okay, they're answering these questions. And they put this article out there. Imagine that you are a local government employee working in the lobby of a county agency. Okay, doesn't even have to be law enforcement. A man walks in holding a cell phone and begins filming the lobby area, including your interactions with people seeking service from the county. Other people that are coming in there to do business. Other people coming in, maybe if you're in a police precinct or whatever, if you're in a police department, people are coming in to report crimes, coming in, people to report, it may be in confidentiality, and you're in there disturbing this. There's considerations why there shouldn't be any recording from a security perspective and from the rights of people walking in there to do business with the police for police business. right? Just throwing it out there. A man walks in holding a cell phone and begins filming the lobby area, including your interactions with people seeking services from the county. When you ask, what is he doing? He says, I'm exercising my First Amendment right to film inside a government building that's open to the public. What do? This scenario occurs at multiple municipal and county offices, police departments, departments of social services, local health departments, and other local government buildings across. This is from North Carolina. You know, but it's happening in prisons too, police departments and prisons, as we have seen, right? And this happens to be in North Carolina. So take that into consideration, too. The individuals filming in these buildings refer to themselves as First Amendment auditors and claim to be testing whether the local government is complying with the First Amendment by allowing them to film freely. This nationwide movement, it's a movement, loosely connected through social media and other online platforms, and anarchist agitators, anarchist revolutionaries, sovereign citizens are involved with that. Loosely connected through social media and other online platforms involves individuals who film their encounters with government officials and employees and subsequently post them on their videos online, especially if they can, get you to tip over and the confrontation. They're looking for the confrontation. They're going to post it on the website, and utilize that confrontation to gain wide notoriety within and among fellow revolutionaries or whatever, right? Okay, responding to First Amendment audits in the local government. They give us a couple things here to take into consideration. See if I can get this a little bit bigger for now. Maybe, yeah. These same two authors, I think here. Yeah, Kristen. All right. Christy and Christina. Okay, contents. The First Amendment and filming. The scope of the First Amendment. How does the First Amendment apply to the act of filming? This is back in 2022 that they put this out. UNC School of Government, right out of the, you can download this document here. Responding to audits, they have information and kind of training and stuff that you can do. You can look those guys up. UNC School of Law, and the same two authors, responding to First Amendment audits in the local government context. Again, they got more of this right here that you can go to. You can look that up. I've got on here of particular interest. It would see pages 15 to 17 on that. Most First Amendment auditors focused on their filming activities on areas that are publicly accessible or within public view. Accordingly, this bulletin focuses primarily on, let me see, sorry about that, just trying to get it in there so we can all see everything that's going on. Focuses on filming activity on areas that are publicly accessible or within public view. Accordingly, this bulletin focuses primarily on forum analysis as a way of local governments to assess the constitutionality of restrictions on filming in such areas. That is kind of what I was asking, and right off the bat when we started doing this, is a public area necessarily a public forum? See what I mean? Just because there's a sidewalk that goes into that building and you have a right to record and the right to do all this, and you have First Amendment rights and this and that and the other thing, there's a terminology, whether it's a forum. There's a difference between a forum, public forum, and a public space, potentially, right? Yeah. Classifying forums. The Supreme Court The Supreme Court's forum classification framework involves specifically identifying the area at issue and conducting a case-by-case analysis of several different factors. To identify the forum at issue, the court looks closely at the specific access an individual seeks. When an individual seeks general access to a property as a whole, the entire property is the forum at issue. When individuals seek more limited or specific access to an area within a property or building, courts apply a narrower approach by identifying the specific boundaries of the precise access sought. So there's constrictions out there, depending on what access is sought. After identifying the forum at issue, courts must class that forum. The government's intent for an area is key consideration for forum classifications. What is your intent? What is the government intent of that area? The government does not create a public forum merely by inaction, okay, or by permitting limited discourse, but only by intentionally opening a non-public forum for expressive activity by members of the general public. So, I don't know. Are they saying that all public areas are non-forums until specifically made a public forum by the government? The government does not create a public forum merely by inaction, so it means it's already a public forum, or by permitting limited discourse. If they allow you limited discourse, does not necessarily make it a forum, or you can't make it a forum by just allowing limited discourse, but only by intentionally opening a non-public forum for expressive activity by members of the general public. So it's a non-public forum until specifically made a public forum by members of, for the expression of activity by members of the general public. Thus, courts must ask if the government intended to allow expression within the forum, and if so, to what extent. Answering that question requires examination. Policies regarding the use and purposes of an area, practices regarding the use of an area, the nature of the property and its compatibility with expressive activity. You know, what's the nature of the business? Is it a secure area? Maybe, right? And the history of the area at issue. Courts consider these factors collectively, and no one factor is dispositive. First Amendment auditors often claim that they have a First Amendment right to engage in filming in a government building because it's open to the public, or in some cases simply because it's owned by the government. How did that work out for J6 guys? You know? How'd that work out for them? Just throwing it out there. However, the fact that an area is held open to the public is not sufficient to establish it is a public forum. I'm telling you right here, this is for First Amendment purposes. And I strongly suggest that you go back and find this site, you know, find this site here by these two professors of law, and you read it. I strongly suggest that you read it, you know. And that's huge. I mean, just trying to figure out where these guys are coming from and what restrictions they actually have, and what imagined or professed rights or super rights that these guys are saying that they have and that they're going to exercise, regardless of what officers say, regardless of what policy says, regardless of what the law says. Because anyways, from an anarchist perspective, all law is illegitimate. All law is illegitimate. Your rights are your rights. You know, that's not a constitutional thing. That's not American founding principle thing. That's an anarchist thing. sovereign citizen thing, which is an anarchist thing. You know? The fact that an area is held open to the public is not sufficient to establish it as a public forum for First Amendment purposes. This is coming from a couple law professors, right? Rather, the area must also be traditionally used for or expressly dedicated to expressive activity. The area must also be traditionally used for or expressively dictated to expressive activity. The Supreme Court has explicitly stated that publicly owned or operated property is, quote, is not transformed into public forum property merely because the public is permitted to freely enter and leave the grounds at practically all times, and the public is admitted to buildings during specific hours, unquote. I'm going to read that again to try and clarify it a little bit more. The Supreme Court has explicitly stated that publicly owned or operated property, quote, is not transformed into public forum property merely because the public is permitted to freely enter and leave the grounds at practically all times, and the public is admitted to the building during specific hours, unquote. Yeah, it is not transformed into a public forum property just because the public is permitted to freely enter and leave. Doesn't make it a public forum. Moreover, in cases where the principal function of the property would be disrupted by expressive activities, okay, think of police precincts, think of any public business anywhere that, like the DMV, and they got business going. Them DMV offices are always freaking crowded, right? You're always standing in line, and you got the smooth running of that, if you can call it that. People are waiting in line. People are being patient. Things are happening. People are in a hurry. You go into a post office. You go into a public library. I mean, there are certain things that, when you go in there, you're there to do your business, and you don't need it being disrupted, right, by somebody coming in there and causing all kinds of havoc because they say it's their right to do it. Stepping on everybody else's right, everybody else's, business to disrupt, all right, to disrupt. That's the word. Moreover, in cases where the principal function of the property would be disrupted by expressive activity, the Supreme Court is particularly reluctant to hold that the government intended to designate a public forum. The Supreme Court is particularly reluctant to hold that the government intended to designate a public forum, which goes back that they have to designate it a public forum for it to be a designated public forum. They have to designate it for it to be a public forum. That's what I'm reading here. Now, I'm not saying that's the legal case. I'm just going over some legal information that's put out here with you, just so that I can show you and make you aware that this exists. I can only recommend that you and anybody that would be interested in learning more about the limitations of these freaking First Amendment auditors that are out there, these so-called constitutional auditors that are out there pushing disruptive, deconstructive agendas, anti-law enforcement, anti-society, anti-state, anti-constitution, disruptive, disrupt the normative, right? Disrupt the normative. That's what revolutionaries do. I can only say that you can read it. I'm just making you aware of this, so for your consideration. This is out there, is what I'm saying. And moreover, in cases where the principal function of the property would be disrupted by expressive activity, the Supreme Court is particularly reluctant to hold that the government intended to designate a public forum. The Supreme Court has been clear that the government may impose reasonable limitations on public expression to preserve its intended use for a particular space. All right. Outside of North Carolina, public courts have found areas of government property open to the public to be non-public forums. This is where I'm going. Outside of North Carolina, multiple courts have found areas of government property open to the public to be non-public forums. For example, the Supreme Court has held that the terminals of a publicly owned airport are non-public forums for First Amendment purposes. Likewise, a court has held that the interior of the United States Capitol to be a non-public forum, like the guys at J6 found out, right? Despite the fact that the Congress allows for the public to observe its proceedings and visit the inside of the Capitol. As discussed in more depth in Section 4, a number of courts have found publicly accessible lobby areas of government buildings to be non-public forums. Now that would apply directly to government buildings, including police precincts, prison administration buildings, prison grounds, law enforcement grounds. I mean, if they're scoping the place out, walking around in there. A number of courts have found publicly accessible lobby areas inside the buildings of government buildings to be non-public forums. Other courts have even held certain publicly accessible outdoor areas to be non-public forums, including open-air plazas connected to government-owned buildings, areas outside of sports arenas, and sidewalks connecting to government buildings. Public access in and of itself does not make an area a public forum. This is where I'm going. This is information that, as you watch these videos and you put yourself in the position of some of these videos, and I can only recommend that if you're in law enforcement, especially if you're coming into law enforcement and you're new to law enforcement and you're going to be going out there on the streets or wherever you're going to be working, that you watch them and you learn more about this law, and then you learn a little bit maybe more between the contention between what these guys are claiming, the rights that they have, and the actual rights in law that limit those rights. You know what I mean? Because these guys, if they're anarchists, if they're sovereign citizen anarchists, or whatever version of collectivist revolutionary that they have, they're not going to recognize any law or regulation as legitimate anyways. That's what, that by definition, what an anarchist is, right? Just some information, good information for you to be aware of, and I can only recommend that you go back and read further into it. Prisons and jails. Same article. Prisons and jails are non-public forums, period. The Supreme Court is particularly reluctant to hold that the government intended to designate a public forum on jailhouse grounds. It's not a public forum. That Paul Reyes, when he goes into all these prisons, so that he can call all the officers out to shame them as quote-unquote non-law enforcement officers, so that he can make fun of them when they respond. Don't touch me. You don't have any authority over me. When he's doing that, he's saying that he has the public forum to do that. There it is. Prisons and jails are non-public forums. The Supreme Court is particularly reluctant to hold that the government intended to designate a public forum on jailhouse grounds, period. Unquote. Just saying. I ain't saying, I'm just saying. In Jones versus North Carolina Prisoners Laborers Union Incorporated, the Supreme Court stated that a prison is most emphatically not a public forum. Not a public forum. This guy's disrupting the normative here. He's disrupting, he's obstructing governmental business. The smooth running of a facility, a correctional facility, which is a security concern at all times. A law enforcement facility. You're disturbing the smooth running, you're compromising the smooth running ability of law enforcement. You're obstructing, you're interfering. You know, a prison is most emphatically not a public forum, quote unquote. Even when the prison had allowed certain external groups to engage in expressive activity on prison grounds. Yeah. So, even though they have been found in Supreme Courts. I'm not sure whether this is a state Supreme Court or the United States Supreme Court, but it says they were talking about outside of North Carolina, multiple courts. But I don't know if this Supreme Court here is state Supreme Court or either way. It's precedent. Right? Yeah. A prison is most emphatically not a public forum. I mean, that's a little shot in the arm for the officers that have been, accosted by guys like Paul Reyes. Especially if when it comes to find out, it's a security concern. I mean, would it be a security concern given these rulings that a prison is most emphatically not a public forum? Would it be made less or more so if that individual accosting officers and asserting himself onto these grounds, these secure grounds, and asserting himself in the officer's space and accosting officers in a, I would say, you don't have to be physically assertive, right? At least accosting these officers. If he was an ex-con that was convicted of a violent Class B felony, robbery in the first degree, would that make it more or less so that, of a security concern? Just throwing it out there. Moreover, the Supreme Court has explicitly stated there is no basis for reading into the Constitution a right of the public or the media. They always try to say, I'm the media. I'm an independent journalist. I'm the media. Yeah. Because the First Amendment is broken down. The freedom of speech and of the press. But just because you're an auditor doesn't make you a press. So the First Amendment protects freedom of speech of the people and a free press. Which one are these auditors, or both of these auditors, trying to say that they're covered under the First Amendment on? Yeah. The Supreme Court has explicitly stated there is, quote, no basis for reading into the Constitution a right of the public or the media to enter penal institutions with camera equipment and take moving and or still pictures of inmates for broadcast purposes. You can't get pictures of inmates. Well, I know on one of those, I did see an inmate in one of the films. They got caught in the film. He wasn't filming the inmate, but the inmate got caught in there. Moreover, the Supreme Court has explicitly stated there is no basis. Sorry, I already said that. Right. In Boulder, Colorado, The District of Colorado ruled that plainly did not have a First Amendment right to film. Let me see, go back here. In a 2021 case, Kerr versus City of Boulder, Colorado, the District of Colorado ruled that plaintiffs did not have a First Amendment right to film with their cell phones on county jail property. And its analysis, the courts noted. In its analysis, the courts noted, quote, jail property is not the type of publicly owned property on which a citizen may exercise the full range of First Amendment rights anytime that he wishes. This conclusion does not change even assuming that the plaintiffs were standing or walking on portions of the jail's property which are generally open to the public for egress, transgress, and egress purposes, for example, by visitors to the jail or for any other legitimate purposes, unquote. Time and time again, these auditors, Reyes, Long Island auditor in particular, keeps saying, I have public access. It says public access here. That does not mean that public access is for what particular reason. Maybe to plug in your electric car. So we're going to allow public access to people here to plug in your electrical car. End of story. You can come on the grounds to plug in your electrical car at this station. Doesn't give you a right to leave here and walk all the way around the jail from this point, that you had, that certain people had certain access for certain reasons. A limited a number of people, or a limited class of people, classification of people with electric cars that can come here and charge. It was part of the grant that they got to put it in, probably, right? Strings attached to public grants for these people to put these electric charging things in. Well, you have to allow public process or public access, right? I'm going to read that to you again, just so that we're clear. Just so that we're clear. Prisons and jails. I'm going to blow this up here for a second so we can. Oh crap! Just one freaking size too. All right. The City of Boulder, okay, District of Colorado ruled that plaintiffs did not have a First Amendment right to film with their cell phones on county jail property. In its analysis, the court noted, quote, jail property is not the type of publicly owned property on which a citizen may exercise the full range of his First Amendment rights anytime that he wishes. This conclusion does not change even assuming that the plaintiffs were standing or walking on portions of the jail's property which are generally open to the public for transgress and egress purposes. For example, by visitors to the jail or for any other legitimate purpose, unquote. It's right there for your consideration. I mean, you've seen on here that when this guy walks up into these prisons, I mean, there's precedent for this. There's precedent for this. But are certain progressive administrations going to feed into the anarchy, feed into the disruption of the normative here? Progressive governments like, Hochul's administration in New York, super progressive, right? Are they going to? How are they going to? Would they interpret it? Would New York State courts interpret this? I'm just saying that there's precedent, and of course, we saw these videos with the correctional facilities in New York State. The officers or lieutenants or watch commanders or whoever came out to read a centralized memo or directive saying whatever the response from central office in Albany was. But I'm just saying. I'm just pointing it out because nobody seems to know how to act with these guys. Nobody seems to, all hands back, hands off. Nobody knows what they can or can't do. Even the outside law enforcement agencies that are being called in, the troopers, they don't have any frickin' clue, it seems like. Of course, the letter of the law has to be taken into consideration with the progressive politics of the administrators, right? Right. Police departments. As discussed earlier, many jurisdictions have recognized a right to record police activities in traditional public forums. However, there is limited case law analyzing the interior of police departments as a forum for First Amendment purposes. In case law that does exist indicates that a police department is a non-public forum. The case law that does exist indicates that a police department is a non-public forum. There it is. The Seventh Circuit has held that the interior of a police station is not a public forum. The Southern District of New York has recognized New York Police Department's meeting rooms as non-public forums. Certain areas, right? Likewise, the Central District of California has held that a police station is a non-public forum. Oh, geez, if it can happen in California, maybe it can happen in New York, right? In a decision affirmed by the Eighth Circuit, the Western District of Missouri held that a plaintiff had no constitutional right to videotape a police department lobby. Likewise, the Superior Court of Pennsylvania upheld a no filming restriction imposed in the lobby of a police department as a reasonable restraint on free speech. There's precedent. There's precedent here to clarify, for clarification, so that the officers, law enforcement officers, can go about their business, with reasonable assurance that they're not going to be accosted regularly and increasingly by these anarchist agents of social change, right? Out there disrupting the normative, and if they are anarchists or sovereign citizens, which are anarchists as well. Even whatever the law says, even if the law says they outright that they can't do it in the place that they are, they're not going to recognize it, because anarchists don't recognize the law as legitimate, because they don't recognize the state as legitimate, which means they don't recognize our Constitution as legitimate. The same Constitution they say that gives them the right to be where they are. Just throwing it out there for your consideration. Rude, belligerent, disrespectful, valid obstruction charge. See, I wanted to kind of go into this here a little bit here. You can be charged with obstruction. I just want a couple minutes of this.
Let's talk about obstruction and when and how it might apply to you. Hi, my name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now. And I want to help you make law easy by talking a little bit about what obstruction of a police officer means and what we can do to try to avoid that. So the statute is relatively short, and I'm going to go ahead and read that. I don't usually, but I want to try to get the wording correct here. Any person who willfully delays or obstructs any public officer in the discharge or attempt to discharge any duty of his or her office is guilty of a misdemeanor. Nothing in this section shall preclude a person from recording the activity of law enforcement in the public area as long as the recording activity does not delay or obstruct the law enforcement agent in his or her duties.
Like if you're on a street and you see police arresting somebody and you whip out your cell phone when you're a reasonable distance and you're not interfering, you're not accosting the officers while they're doing it, you have a right to do that, right?
So, what this means is you cannot get in the way of an officer trying to perform their regular duties. If you see an officer doing a traffic stop, you can't go get in their face and start calling them pigs and try to fight the system or anything like that.
Which is what they do. It's going to find something on there. I didn't find it.
Or if you're the subject of a traffic stop, if you're being rude or belligerent or, making it take longer than it should, you could also be guilty of obstruction. I've had plenty of clients who, when they've been pulled over, they're refusing to give their identification. They're refusing to give their insurance. They're refusing to, do the field sobriety test if that's what the officer is wanting to do. Whatever the officer, in the scope of their employment, is trying to say needs to be done either by you or by them in order to move things forward. If you're getting in the way of that, you could face an obstruction charge. So what do? Obviously, we want to be respectful. I can't tell you how many times I've told my clients or shot in these videos and I've said, you have to be respectful to law enforcement. You may not like law enforcement. You may have, political or personal ideas about, police officers and their job and what their role should be. That's fine. You've got to put those to the side in that moment and just be respectful, be courteous, and cooperate as much as you can without actually, violating or, damaging any of your rights. Your rights.
How many of these First Amendment auditor videos, you can go out there and watch as many of them as you want, and they feign respect, but how many are actually being respectful versus how many are being outrightly disrespectful, hostile, let alone not just respectful, or how many of them are being actually hostile.
Rights against, search and seizure, your rights against self-incrimination. Those are valid rights, and you want to make sure that you protect them, but don't do so in a way that's going to be rude, belligerent, or disrespectful to the police officer. Otherwise, you could be facing an obstruction charge. And those are valid charges. Even if someone says, oh, well, I was just protecting my rights. Well, if you don't do it in the right kind of way, you still could be facing criminal charges for how you act in those situations.
This is information from a lawyer, right? Just being disrespectful, getting up in her face and, causing a disturbance or whatever, just being disrespectful, it could be an obstruction charge. And another thing I want to point out, too, and this is how social media works, on YouTube. This has had, this has had 82 views in 4 months. This had 82 views. Well, the ones being disrespectful to cops are getting hundreds of thousands, if not millions of views. Tens of millions of views in some cases, right?
So use your best judgment, and if at all possible, just defer to what you would want to do in a situation where if it was, someone speaking to your mother or speaking to your brother or speaking to your daughter, you'd want them to be respectful, so show that same type of respect in return. If you have questions about this, please give us a call. My name is Carl Burkhead. I'm with Worth Law Office, and I want to help you make law easy.
I just wanted you to hear that because I found it interesting that you're watching these videos and the officers don't know how to respond to these guys. They're of course they're getting their administrations don't know. Their brass doesn't know how to freaking respond to these things. Their administrators don't know how to respond to these things because now you've got the progressivism on the street coming into conflict or potential conflict with the progressivism of your administrators that disrupt the change, disrupt the normative freaking stuff, and then the officer's caught in the middle of that shit. This is what's happening. And that was the theme, the main concern that I had for officers out there when I wrote 10 years ago, back in 2015, I wrote that article, Target America Officers at the Forefront, warning people that these type of things that were happening and critical theory, the critical race theory that was coming from on the streets, and the doctrine that it came from, and how law enforcement is held in the eyes of these transformative, vanguards of revolution. That's what it is. Okay, the fundamental transformation of America, if you want to call it that. I mean, it's all part of the same larger revolutionary progressive collectivism that has targeted our founding principles and republic for destruction. Not all of them have targeted the state for destruction. Some of them want to just take over the state and utilize state power for collective, for Marxist or communist revolution, whatever. Some of them want to get rid of the state altogether. All of them have equally targeted our republic and our constitution, the constitutional republic, for destruction. Just putting that out there for your consideration. I got the right to public forum doctrine, public place and public forum. I got the Center for Homeland Defense and Security. I got a little thing here from them. The Journal of the NPS, okay. Center for Homeland Defense and Security, Civil Rights Auditors, defining reasonable time, place, and manner restrictions on First Amendment activities. I'm not going to watch this whole thing.
With some of us.
You had a very interesting research topic. How did you come across it?
We all came to this program with some of us with more, some with less, but we each had problems we were hoping to solve. And most basic level, there's one type of citizen journalist that's called a cop watcher that just will show up and record police in the public place. And the court said that they can do that. But I didn't really focus on them. I focused on one that they call themselves a civil rights auditor. Mm-hmm. And they show up and they'll record a third party to generate a police response. And that leads to their desired, in most cases, police-citizen conflict for their YouTube videos and other social media.
And so your research focused on what question?
Well, regarding them showing up and recording you, we know the Supreme Court says they can record me in public, but can they record you in your federal building, government building, military base, or even a hospital or a synagogue? And so that came to the question of what are the limits to this First Amendment activity of recording in public?
That's a big topic.
It is a big topic.
And so what type of methodology did you use in your research?
Well, the first thing I did is like most research, is I kind of reviewed what is the existing literature, what is the case law, what have scholars written about this. And in doing so, what I found was that the courts have not, at the appellate or Supreme Court level, looked at this issue specifically. They've looked at the cop watcher, but we knew that. But they haven't looked at this specific scenario.
Meaning they haven't come down
They haven't answered the question of to what degree can they record you when it's interfering with your security or your business function or so forth. At least not on an auditor case. Mm-hmm. And then when I looked at the scholarly research, I really found two types. Some of it simply echoed what the courts had said, and we knew. Some of it championed the cop watcher for recording police and the change that would have on law enforcement and the accountability that brought to law enforcement from their perspective.
Right.
So.
And so how would you move forward? Because it is quite contentious. It does have a lot to do with trust in law enforcement. What surprised you about what you found in that research?
Well, like I said, I didn't really find anything specific to the auditors. Mm-hmm. And to where you're saying, I'm calling the police. Trying to give your personal information to the person at the counter and someone's recording, that inhibits that business function. Mm-hmm. So what the courts have said is if that activity is incompatible and you're in a non-public place, you can restrict that activity as long as it's reasonable. And that is what public forum doctrine is. It's just determining what is the forum where this activity is taking place, what is the level of compatibility with our business. And at the very bottom, you cannot restrict it simply because you don't like what they're saying. And I think that's where we tend to not realize there's a problem till the one auditor shows up who's the most caustic, and then we want to impose these restrictions. Well, it's because we just realized this doesn't work. But it's not what they're saying. It's the manner in which they're behaving and the things that they're doing that disrupts the business.
It's not what they're saying. It's what they're doing that's disrupting the business of the agency or entity or business that they've gone into to push themselves on everybody, right? This is what I'm getting at. This is just another thing here where you got Homeland Security Affairs discussing the matter. Let's just list a couple more minutes.
But that has to be thought through, and obviously there's legal differences in every single state that have to be explored to make sure you're not, violating other restrictions.
Well, I would say the average citizen doesn't know the difference between a public place and a public forum, right? So that's a matter of educating all of us.
Yes, that's true. And I found that it's not just the citizens, and some of the literature that we put out, we being the government, if I'm putting myself in that category.
Whole government. Yeah.
From the federal government down, conflate the concept of public place and public forum. And when they do that, they create problems for us. There are policies that have been written by the IACP and by DHS through DOJ, helping Baltimore Police Department, for example, write their policy. They deal with First Amendment activities and police response to that, but they're only looking at what a protester or someone in public, a cop watcher, would do. So they're really only looking at where police would be imposing these restrictions. But if it's your building and you've set the restrictions, then we're not imposing them, we're enforcing them. So there's a whole separate thing that's not mentioned in these policies. And to prepare for police better and reduce citizen police conflict, our policies need to include the whole gamut of what can be done.
I just wanted you to see that. I recommend that, that everybody watch that whole video. Just putting it out there for your consideration. Just because it's a public place doesn't make it a public forum. This is where I'm going. Maybe we can get to a point where when people start coming up to officers on the street and accosting officers, to the point of what is interference and what is obstruction, we can get clarifications on this. I mean, I've seen where some of these people out there are actually playing music when these First Amendment auditors are out there. They're playing music that's, patented, copyrighted music, so that they can't post it, or if they do post it, YouTube takes it down because they've got copyrighted music on it. I mean, there's different things that people have been doing to, kind of curtail what these guys are doing, but I've got here, let me see, civil rights auditors defining reasonable time, place, and manner. This is also from Homeland Security. By defining constitutional boundaries, this thesis expands the scholarly knowledge about auditors, allows agencies to develop accurate training and policies, and equips officers for these encounters. Common auditor-created legal challenges and issues emerge in the research and provided scenarios for legal analysis. Furthermore, specific language of these policies and the mutual confusion of the terms public place and public space potentially position agencies for failure. This thesis is paramount to law enforcement and the community because an officer reacting incorrectly in these encounters can, through action, create conflict, loss of police legitimacy, or liability for the officers or their agencies. Or conversely, through inaction, miss an opportunity to intercept a genuine threat. Right. Because because an officer. This thesis is paramount to law enforcement and the community because an officer reacting incorrectly in these encounters can, through action, create conflict, loss of policing legitimacy, loss of policing in legitimacy. That's what anarchists are out for. That is the big picture of what any of these quote-unquote constitutional auditors, First Amendment auditors, that's the objective. That's the revolutionary vanguard objective, is to create, if not actual illegitimacy, at least, apparent illegitimacy. The illusion of illegitimacy. They twist all shit around. You see the thumbnails that they put out there. Just look at the thumbnails with the titles of the video. But this is a video. I got that from here. Homeland Security Library, Civil Rights Auditors defining reasonable time, place, and manner restrictions. I highly recommend that you read this article. Okay, just putting it out there. These guys can end a career in a heartbeat, and they've done it. They love that shit. Just so you know, just so they know. It's even better if you embarrass or bring down your whole department, or compromise the authority of law enforcement altogether, or delegitimize the state altogether. I got the right of publicity. There's another one here. What is the right of publicity? The right of publicity is an intellectual property right that protects against the misappropriation of a person's name, likeness, or other indication of personal identity, such as nicknames, pseudonyms, voices, signature, likenesses, or photograph for commercial benefit. This is movies, singers and actresses and stuff like that started all this, really. In the United States, no federal statute or case law recognizes the right of publicity. A majority of states do. No federal statute recognizes the right of publicity. A majority of states do, however, recognize the right of publicity by statute or case law. The right of publicity. Law meets social media. Publicity. You have a right. You have property in your identity. You have property in your likeness. You have property in that. And somebody else, if you're on the street and you don't have any expected privacy, is like what they would try to tell us. If you're in a public place, on a sidewalk, in the street, or whatever, you can't have any, a real expectancy of any real privacy. But, people can record you and all this and that and the other thing, but they don't have a right to record you necessarily. To record people in public, random people in public, and then take their likenesses, their names, their their identity, and post it for financial gain or for profit. Once they do that, you see a lot of these First Amendment auditors. I mean, they're getting people from Joe Public out there, Joe Civilian, with their hands in the face. People drive by saying, "Don't you record me? Don't put me on there." Yet they do it anyway. Accordingly, that's potentially a crime in and of itself. All those people that they have faces of on and likenesses of that aren't blurred out, that they're posting for profit. Maybe that's an avenue through which people can say, "Yeah, this right to publicity meets social media." Let's dig into it a little bit, right? The right of publicity is an intellectual property right and branch of unfair competition law that protects against the unauthorized use of an individual's identity. All right? The right is not governed by federal statute, but is recognized in just over half the states through both state statute and or common law. The right of publicity origins can be traced to the right of privacy. a personal right that Samuel D. Warren and the future U.S. Supreme Court Justice Louis D. Brandeis described as, quote, the right to be let alone, unquote. The right to be let alone, unquote. You know? The right of publicity statute and in interactive mail. Oh, see, I got that article from here. This is a lengthy document here that you can get. If you want to read more on that, that's where you can go to see that. The right of publicity statutes and interactive map. The right of publicity statutes states that recognize them, I guess. The right of publicity is a state-based property right in the United States. Each state determines the parameters of recognition. A statute is not a prerequisite for the right of publicity to be enforceable. That's huge. We don't have a right to any of our property via statute. Our right to property is a natural, endowed by our Creator right, secured by the Constitution, via the limited powers that government has sanctioned. That's what our Constitution is. It's a government power limiting document, not a giving people rights document. You see what I'm saying? A statute is not prerequisite for the right of publicity to be enforceable. It's not. You don't need a statute to say, I'm going to protect my right to property in my identity, in my face, in my name, or character. See what I'm saying? Just something to throw out there for your consideration. Louisiana, Alabama, Arkansas, New York, and South Dakota are all among the most recent to pass right to publicity legislation. California passes a critical amendment to its right of publicity statute in the wake of the Marilyn Monroe cases. The author of this website led the amendment to Indiana's right of publicity statute, and New York only recently broke out of its stalemate concerning publicity rights. Huge. A statute is not a prerequisite for the right of publicity to be enforceable. So, I mean, this is an avenue to explore. There's case precedent out there. There's natural law, common law precedent. And the whole concept of what our property rights are. We don't need a statute to protect our natural, endowed by our Creator, individual rights and liberty, including the right to property. And then we do have property in our identity. Intellectual what do they refer to? Intangible rights, right? It's an intangible. I guess it would still be intangible because it's your face, it's your likeness, it's your, it's your identity. They can't just post pictures of you and video of you online and make money of it. It's a violation of your property rights. That's what I'm getting at, and kind of what I'm throwing out there for your consideration. An avenue through which maybe people can push back on this if they feel like they looking for an avenue to do so. Just throwing it out there. Right to privacy. Statutes in New York. Right to publicity in New York. A person, film, or corporation that uses advertising purposes or for the purposes of trade the name, portrait, or picture of any living persons without having first obtained the written consent of such person, or if a minor of his or her parent or guardian is guilty of a misdemeanor. It's a misdemeanor charge. 51. Action for injunction and for damages. Any person whose name, portrait, picture, or voice is used within the state for advertising purposes or for the purposes of trade without the written consent first obtained as above provided may maintain an equitable action in the Supreme Court of the state against that person, against the person. Posting people on, they're obviously making profit by these shows when they're posting them on there, and YouTube's giving them tens, if not hundreds of thousands, if not millions of views on this. They're collecting buku bucks on it. So there it is, right there, right? Let me see. Yeah, for the purposes of trade. The picture or voice is any person whose name, portrait, picture, or voice is used within the state for advertising purposes or for the purposes of trade. Okay? So using his name, portrait, picture, or voice to prevent and restrain the use thereof, and may also sue and recover damages for any injuries sustained by reason of such use, and if the defendant shall have knowingly used such person's name, portrait, picture, or voice in such a manner as is forbidden or declared to be unlawful by Section 50 of this article, the jury and its discretion may award exemplary charges. So all those people that they've got on their tapes, on all those videos that are posted all over YouTube and have been posted all over YouTube for years now, right? Every single civilian that's on there without permission could potentially sue these guys for damages. That's what I'm getting out of it. I'm not saying that's what the case is, but I'm saying it appears that way, that the potential is there for that to happen according to what we're reading here. According to the right of publicity in the state of New York, right here, right? Well, First Amendment auditors, the Americans who pick fights with police for cash. And this comes from this article here. I just wanted to put this out there. First Amendment auditors, Americans who pick fights for police with cash. Yeah, this guy here, Sean Paul Reyes, 30, this is back in 2021. On that charge back where we looked at Paul Reyes is when he was incarcerated for first-degree attempted robbery. Class B felony, violent felony, right? When he was sentenced to 3.5 years, he went to Ulster Correctional Facility and Mohawk Correctional Facility in the state of New York, inmate in both jails, where he sued the state after he got beat up by the other inmates, right? It said that his birth date was 1991. This article is 2021, says Sean Paul is 30, so that matches up. It just matches up, right? Same age, same name, same age. You know, just saying. It says he earned $8,000 in his first month as an auditor. So he's making money. He's making money. And yeah, I just wanted to put that out there. First Amendment auditors insist that they are standing up for free speech, which is okay. Police say they're making their jobs harder, yes. Law enforcement jobs harder. It's not only that, through their revolutionary efforts, revolutionary vanguard efforts, they're potentially, and in some cases I would argue have compromised the authority of law enforcement across the board. That's what they're looking to do. Law enforcement awareness. I got in here, are you an anarchist? Lawyers, New York State Police grilled protesters. And this one, I just wanted to put this out here. I got this from Yahoo. I don't know. Reuters. Are you an anarchist? And this is what they're saying, that police violated laws just for asking if you were an anarchist. A group of lawyers say New York City police and federal agents may have violated a long-standing order limiting their investigation of a person's political beliefs by asking these and other questions of the same protesters, of some protesters that were detained. But like that other lawyer said, like those other Homeland Security individual was saying, it's not what these people are saying or the political beliefs that they hold. It's the disruptive actions that they've taken or are taking, right? Anarchist direct actions, a challenge for law enforcement. Here's direct action again. Like I said, anarchist direct actions. It's a thing. I'm not just making this shit up. Okay, ResearchGate. This is a white paper. Came out in 2024, right? Randy Borum, University of Florida. Okay. Their challenge to law enforcement. These anarchist direct actions are a challenge to law enforcement. I've got in implementing a strategy of direct action. Modern anarchist leaders have looked into the experience of prior revolutionary movements in America. One of the most prominent modern examples is the communist Weather Underground organization, like I said before, a new left, radical splinter faction of the Students for Democratic Society. That operated between 1969 and 1976, and if you go back, I've already mentioned these guys a couple times here. Although the underlying political philosophy of the Weather Underground was a communist in seeking to overthrow the U.S. government, they shared anarchist goals of destroying capitalism, all right, and they certainly shared the philosophy of direct action. The Weather Underground inaugurated its violent campaign on October 6, 1969 by bombing a police memorial in Chicago, igniting the days of rage. Just throwing it out there first so that you're aware. Then they led a destructive mob of about 300 through the streets of Chicago, vandalizing businesses and vehicles. Several people were shot that night, and there were other violent confrontations with police for a couple of nights thereafter. I'm just saying that these guys are up in their game. They're out there. They're going to be up in their game. It's just the natural process of things. And when they do, it's not like they're going to be breaking new ground. These anarchist agents of change, direct actions that they're taking, like these First Amendment audits and quote-unquote constitutional audits that don't recognize laws, they don't recognize, codes, ordinances or whatever. They don't recognize. They're invalid to them. Okay. New Left side notes, I just wanted to point out here that some of the Maoist Trotskyists, anti-American New Left revolutionaries that also came out of the New Left, the Weather Underground, Lyndon LaRoche PAC. I've done shows on guys like Matthew Ert and stuff out there promoting all the confusion and convolution that's put out there, diving into our history and changing our history and putting it out there to advance revolutionary purposes and against America as founded. The neoconservatives on the right, the neocons, they come out of the same New Left. Just putting it out there. Scientific Engineers and Social Political Action, CESPA, part of the American Association for the Advancement of Science, is a recognized, also out of the New Left. This American Association for the Advancement of Science, I also want to put out there that they're out there training our courts, out there training our court system in this same revolutionary progressive collectivism and global governance doctrine, and how to accept the captured social science of revolutionary collectivist doctrine, including climate change, anthropogenic climate change. So they're training our courts to accept this revolutionary direct action in the courts. I did a show on it. I've on 2 or 3 shows that I've done ago before. If that kind of thing interests you on how this revolutionary progressive collectivism and its agents of change, and global governance change, have infiltrated our courts and whole justice system, you can check that out. I just wanted to put that out there. On Influence Watch, I just wanted to show you where I got that from. You can check it out. Scientists and Engineers for Social and Political Action, CESPA, Scientists and Engineers for Social and Political Action, was a communist organization created around 1969 to oppose U.S. involvement in Vietnam. The American Association for the Advancement of Sciences officially recognized CESPA as a legitimate part of their organization in 1976. I just wanted to point that out. It's the same malevolent show on a multitude of levels that we're dealing with. And it's the same revolutionary progressive collectivism on a larger scale, on a global scale. It's not just national, it's global. It's a global philosophy. You know, it says right here that CESPA members visited Hanoi, the capital of communist-controlled North Vietnam, with, like, was that Jane? The hell was her name? I can't think of her name right now. Jane Fonda, right? Yeah. Shortly thereafter, Science for the People began CESPA organizing support for North Vietnam government, prompting the FBI to classify CESPA as a revolutionary activity or New Left organization for aiding the enemies of the United States during wartime. Just putting it out there, okay? Okay, sovereign citizens. Sovereign citizens are part of this too. Introduction to law enforcement. They've got information out there that you can check out. They've got information on who these sovereign citizens are, sovereign citizens, and introduction to law enforcement. You can go down through this. It's very interesting. I remember it was back in the the mid-90s maybe. Mid-90s, maybe right around 2000, somewhere in there. The sovereign citizens, inmates were all claiming to be sovereign citizens, a lot of them. And it just threw the courts into a tizzy. They didn't know what to frickin' do. You know, and finally they just decided that everything that these sovereign citizens were doing was just illegitimate bullshit. It was just freaking quack shit. But they're agents of change. They're revolutionary vanguard is what they are. It's nuts. A lot of it's built on conspiracy theories too. A lot of these people get out there and they get hooked on the conspiracy theories, and they start, you know, getting involved in these sovereign citizen kind of shit. You know, these First Amendment audits too. They'll get legitimate, you know, Constitution-loving people sucked into the movement, thinking that that's what they're actually doing. But you got to really be careful. You know. As a matter of fact, I've got real quick. Here's a sovereign citizen guy here.
I guess this is the revenue office.
Don't mix pink salt with lemon and 2 other ingredients if you don't want to donate your entire wardrobe in less than a week. Don't believe me? Give me 60 seconds to explain. This is the pink salt trick that took me from 179 to 126 in 2 weeks. Or better yet, the $2 natural version of Zepbound. Let me show you how easy it is to make this new natural Zepbound recipe that's going viral on social media with over 21 million views among the women who want to go from extra, extra large to medium. Many of you missed the day I
Had to figure shit out there. I'm sorry about that.
It's an old bank vault. It's kind of cool. Oh, old world map. I dig that. That's awesome.
Just walking around a building.
I'm just me. Yeah. Oh, I'm sorry. I'm just getting some footage. I don't need any help. But thank you. Just because I'm a photographer.
Well, this isn't a sovereign citizen, I don't think. I got the other one to show you.
It's public, isn't it? I've got permission. James Madison and the Founding Fathers. Under the First Amendment. I'm not trying to be ugly.
So I'm blurring out all of the women's faces in this video because a day after this incident, JC received a protection order from one of them for sexual harassment. Sexual harassment may also come into play for his most recent charges he's currently wanted for. Before we continue,
That's what I'm saying. These guys that are walking around these offices and accosting these girls or people that are at these office desks in these public buildings, you don't know who these guys are. There's no way of knowing who these guys. He's either off the rails or he's pushing an agenda, or he's got criminal intent and undercover of a First Amendment auditor or whatever. And the potential is endless, right? But anyways, I wanted to kind of point that out so that you're aware of that. And I wanted to show you this too. Yeah, here's another guy.
And that breaking news involves the arrest of a Houston area man known for making YouTube videos criticizing police. Late this afternoon, Earl Worden was taken into custody by McAllen police after being charged with sexual assault of a child. These allegations date back to 2002. New evidence was obtained by Deer Park police that led to the new charge. Over the years, Worden has appeared in dozens of YouTube videos criticizing law enforcement and challenging the legal limits of where people are allowed to record videos and take photos. Worden is already a convicted sex offender. It is not clear why he was in McAllen. He will eventually be brought back to Harris County to face a judge on this new charge.
Breaking news alert.
Wanted you to see that. Again, another guy, another sex offender guy. I mean, these auditors, they aren't, you don't know who they are. And I'm just putting it out there that there's reasonable cause to believe the potential for danger is real. You know, would a reasonable person be doing these things? But he was a sex offender. He wound up doing 20 years. I started looking into that guy, and I don't know, sex with a minor girl, and according to some of the articles I was reading, it was his own daughter. So I mean, you can look into that to see if that's true, but I'm telling you, there's legitimate concern for the safety of public employees when these guys come into the room and they come into your building and they stick these things in your face. I'm just saying, just putting it out there for your consideration. Here we go. Here, First Amendment auditors, legal strategies, enforcement, and current case law. This is this article here. This is what. This is a powerful new program. Seasoned attorney Scott Wood will interpret the parameters and the nuances associated with the First Amendment, spotlighting the new auditors movement, and discusses how it all impacts police officers. I got a couple things here. You may also like constitutional use of force, legal to reasonable force issues, legal to reasonable force, implicit bias, understanding its impact on actions, decisions, implicit bias training, duty to intervene, legal updates and police policies for officers, intervention. That's kind of under the same thing here. But course description, you know, First Amendment audits always uncomfortable and can be disruptive, but they are practical. There are practical ways to prepare and respond, and then they have trainings. They have actual trainings from a multitude of different police agencies and municipalities have put out all kinds of how to respond thing. And depending on how progressive the administrators are, they won't show you some of the things that I've shown you. But, you know, they are coming out with policies, just like they did with the sovereign citizens. They finally figured out it was all freaking illegitimate freaking bullshit. They never come out and actually said it's revolutionary bullshit that it was, but they just said it was illegitimate. And hopefully they'll come up with ways to curtail what they're doing with these guys too. Police one, you're on camera, how police should respond to First Amendment audits, just like I was saying, you know. This police one, I don't know, they've been pretty progressive organization anyways. So it would be interesting to see what they come out with, you know. They say, as law enforcement officers, we are obligated to enforce laws and statutes during the course of our duties. We must also realize that it's our behavior and actions are governed by the same laws that we are sworn to uphold. Yeah, we swear an oath to the Constitution. We don't swear an oath to the anarchist interpretation of that Constitution either. Just throwing that out there. We are currently seeing a trend in people filming law enforcement, often referred to as First Amendment audits, again, as being a separate entity from like the cop watchers that other guy from Homeland Security was talking about. If you're on the streets and you're chasing a guy down the streets, or you're making an arrest on the street and somebody whips out their cell phone from across the street and just records the incident, that's not illegal. Nor should it be, right? And I just got down there. As law enforcement officers, we all swear an oath to the Constitution, at least for now, until they say that the Constitution's an antiquated document, basically enforcing an antiquated white supremacist, oppression of the oppressors, of the oppressed, or some shit like that. But as law enforcement officers, we all swore an oath to the Constitution, at least for now. There still will be, until the day comes, and it's coming, that abolitionist and or critical 21st century progressive policing efforts make their move to eliminate it altogether as an antiquated pledge of allegiance to a capitalist, property-based individualism and patriarchal privilege. Whiteness of America, no longer tolerated in the centralized collectivism of a progressive American society. Just wanted to get these things out there for you. I want to wrap this up. I hope you got something out of this series. I'll continue to look into it. I mean, if you've got anything that particular concerns about it, give me leave the email in the show notes to contact me with questions and certain things to look into that I can help you out with. I don't know, but they've got ex-cons out there, violent ex-cons out there that are doing this shit. Now they're not only doing this shit now and getting in the faces of officers, soliciting and fishing some kind of embarrassing situation from officers. You got to stay cool. You got to stay cool, and learn where these guys are actually violating actual constitutional rights, actual public forum policy. And maybe we can learn that together and start to curtail this a little bit. And the civilians that they're actually getting recorded and putting out there for profit, people have property rights in their identity. There's a number of different ways, that people can defend themselves against these rogue individuals, these agents of revolutionary disrupting the normative. They're vanguard movement. You know what I mean? And for the most part, they're a vanguard movement. Hope you got something out of it. My name is Joe Marshall. Thanks for stopping by the Liberty Perspective, and I look forward to seeing you in the next show. Thank you.